If you've been charged with domestic violence, even if you haven't been to court yet, one of the things that you should always start thinking about from the beginning is, if this case goes to trial, how likely am I to win? In fact, that is what defense attorneys and prosecutors look at from the very beginning, even when the prosecutor is deciding whether or not to file charges. Now, one important consideration is, if it goes to trial, should you testify? So in this video, I'm going to be discussing 5 important considerations that you should think about before making the decision as to whether or not you should testify. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be talking about the 5 things that you should consider when you're making the decision as to whether or not you should testify at your domestic violence trial. And by the way, number 5 is the most important out of all of these. If my client falls in this category, then I'm going to tell them you absolutely should not testify. And if you do so, you're doing so against my advice. Okay, so let's jump right in. Number 1, do you have any prior criminal convictions that can be admitted into evidence only if you testify? There are multiple factors that the judge has to apply to you specifically, in your case specifically, when making this determination as to whether or not your convictions are going to be admissible. And this is something that your lawyer should litigate before the trial, and even before litigating it and filing a motion to keep the convictions out if you have them, your attorney should be able to advise you on the situation and whether your convictions are likely to be admissible, and admissible only if you testify. Number 2, does your version of the story make sense? You could be telling the truth, absolutely, but sometimes truth is stranger than fiction. If your story just sounds too weird, or like something that, considering the evidence, your actions don't sound like what most jurors would agree with or what they would think would sound reasonable. This could be something like your reaction was very different, or what you say your reaction was very different than what most people would imagine themselves doing. So for example, catch your wife in bed with another man, red-handed, and you're not angry. You're perfectly calm. Now that could be, right? If you're thinking about divorcing her anyway, you're just trying to figure out how to do it, and you're like, well, this makes it easy. Or maybe you're cheating on her too, and you're like, all right, well, I got one, free chomp there. She got her free chomp. How mad can I be? Maybe you've been wanting to engage in polyamory for quite some time, and now this is the perfect way to bring it up to her. Now, any of those explanations, those could be the case, and some of them, depending on how much evidence you have for those actually being the case, maybe would come across okay to a jury. But for the most part, I think most people think if you catch your wife in bed with another man, you're going to be angry or devastated, you're going to be upset. So if you're going to testify that you were just fine with that, and you calmly close the door to give them some privacy, and that's your story, maybe you shouldn't be testifying. Number 3, your likability, your demeanor, and your ability to handle cross-examination well. So first of all, some people, they just don't come across as likable. We all know this, right? There's RBF that some people have. Some people, when they get nervous, their demeanor is really bad. Maybe they have little tics and they look like they're lying, and they look all around and they won't make eye contact even though they are telling the truth. If you're like that, you probably shouldn't testify. And the ability to handle cross-examination. Okay, so imagine you're sitting up there on the witness stand. At this point, the point of trial, you've been through a lot with this case. You have had to pay to bond out, or you're in jail and you haven't even been convicted of anything, which I think would make most people a bit frustrated. You have dealt with the prosecutor. Negotiations, settlement negotiations never panned out. Maybe the prosecutor said some really mean things about you and you heard them, or your attorney told you about them. You're nervous. You have to see perhaps your ex testifying against you, lying about you being treated like they are the innocent victim when you know that they're a lying snake. Maybe the judge has been a jerk to you and you're missing work for all of this. Hopefully, if you're going to trial, you have a private criminal defense attorney. You've paid them a lot of money to be there. This is money you will probably never get back. And it's frustrating. And now you have this prosecutor, the person who, for months, has been treating you like you are dirt. The person who did have the power to make this go away, but has decided that they want to put you in jail or prison or ruin your life with a conviction. And after you give your side of the story, they're going to try to make you look like a liar. And for domestic violence cases, they're probably going to try to get you to lose your temper. So when you're thinking about how well you handle cross-examination, you're going to have to think about how well you can make sure that you don't seem angry at all. You're not even clenching your fist. This is going to date me, but if you ever saw the MTV show Boiling Point, I really liked that show. What happened on the show is that they would have like a hidden camera, and I'm sure it was all fake and staged. They had a hidden camera, and they would do really annoying things to people to try to get them angry. And if you made it the whole, I think it was like 10 minutes without getting angry, then you would get a prize. I remember watching that show even in junior high and thinking I would never get the prize. I would get angry. And I think as I've gotten older and as I've gone to law school and as I know what the judge and the jury are looking for and how people look on the stand, maybe I would be a bit better now. But you know, if you are one of the people that would pass and would get the prize, or if you're not. If you're like, I would get upset. I would be one of the people that raises my voice or swears at them or pounds my fist on the table. Then you probably shouldn't testify. There are also people who go on for a long time when being asked a yes or no question. On cross-examination, when the prosecutor is asking you questions, if you testify, typically the questions that you are asked are going to be yes or no. And of course, you don't want to agree to anything. If it's not really a yes or no question, or it's partially true or partially not, then of course you would want to state that. But if you are going to go on for a really long time or not answer the question directly, you're very likely to come across as evasive. And in that case, you probably shouldn't testify. Number 4, how strong was the other side's evidence? So at trials, the prosecution goes first. They present all of their evidence and then they rest. And it is then the defense's opportunity to present their evidence. And they don't have to, and sometimes we don't have anything, especially if the client isn't going to testify. We don't have anything and we're just poking holes in what they have. And the defense doesn't have to prove anything, but the prosecution has to prove to the satisfaction of the jury that you are guilty beyond a reasonable doubt. If they fail to do so, then they lose the case and you win as the defendant. So let's say that whatever they presented was incredibly weak. Let's say that they cannot find the victim to serve her with a subpoena and make her come and testify. I'm saying she, it could be a male or a female. I'm just using she because that's the most common, it is for simplicity's sake. And she didn't testify previously, because if she testified previously, then they can potentially use that prior testimony. But let's just say they had nothing from the victim at all. And importantly, they don't have any other statements that can be admitted. So for example, when the police are interviewing someone, many times they will have body-worn video. So let's say on that body-worn video, the alleged victim does say that you did commit domestic violence. Well, a judge is going to have to look at that and decide, can this be admitted or not? It could be considered hearsay where it doesn't come into evidence, or it could fall under one of the exceptions. And we spend about half a semester in evidence class learning just about hearsay and the exceptions. It's complicated. And it could be that the prosecutor thought that they would be able to at least get that in, but the judge said no. So perhaps they have nothing from the victim, and maybe they have a neighbor saying that they heard some loud banging sounds and some yelling, and that's it. And they did have a police officer testify as to injuries on the alleged victim. They don't have a whole lot there. Well, at that point, why are you going to go on the stand and potentially give them more evidence? Their case is so weak. So it may not be worth it to take the risk, and it's always going to be a risk, of having you testify. It might be better for the defense to simply rest. Number 5, are you guilty? If you are guilty, then I do not think that you should testify. There are a few issues here. First of all, your attorney can't put you on the stand if they know that what you're going to say is false. We're not allowed to do it. Now, there are some nuances here. You could potentially go on the stand and testify in the narrative format, but if you get to that point, you probably shouldn't be testifying. So what does that mean? If your attorney can't help you come up with a lie, then you're doing it on your own. And the problem with lying is that you can potentially get caught. So it's just not worth it. And there may be details that you haven't thought of, especially if your testimony is long. You may describe the same thing twice, but you accidentally get some details wrong because you're lying. There may be evidence that you forget about, or maybe your attorney didn't show you, that can impeach you, that can show that you are lying. So if you're guilty, and you know you're guilty, then it would be better for you not to testify. Now, obviously, there's some gray area. There's self-defense, for example, and there can be an issue of, did you use too much force? Well, you don't necessarily know that. It's more of a reasonable person standard. In those types of cases, the best thing to do is to tell your attorney the truth and then take their advice on whether or not you should testify. I hope you found this video helpful. If you do have a domestic violence case in California that you need help with, feel free to give me a call. You can find my number down below. You can also find a link there to book a consultation. And if you did find it helpful, please don't forget to like, subscribe, and ring the bell.